Joining me now is Sara Azari. She is a criminal defense attorney and News Nation legal analyst, and David Katz, a former assistant U.S. attorney and criminal defense lawyer. We thank you so much for being with us, David and Sara. Sara, I want to start with you. We're going to get to Kohberger in a second. There's a lot to talk about there, but I want to quickly talk about this new Menendez filing. We did the story a couple days ago on the show. There's new evidence. They want a new trial. They haven't gotten responses in the past. This new filing came in tonight, literally. What does it mean?
Yeah, there's significant new evidence, and you have to wonder whether if this case had been tried today, if they would have been convicted. I think it is a big deal considering the, I practice in Los Angeles, the LA DA that we currently have, George Gascon. He is one of the most liberal. There's been attempts to remove him because he's so liberal. And if anybody is going to pay attention to this kind of case, and really what Garagos is arguing is an injustice, is this DA. And so I see this filing as, of course, on its face, it looks like they're asking for an extension of time to file their response, but they're actually paying attention. They're saying that the defense has agreed to turn additional information over and that they're actually going to take a closer look at this, whereas at least in the last decade, their filings have largely gone unresponded to. Yeah,
I find it fascinating. After we had Garagos on the other night, I spent like 3 hours just watching the Menendez brothers' testimony. And you mentioned, it was a different time.
Yeah.
I was young. I don't remember it that well, but they were crying. I can't believe the way that played out. It's going to be really interesting to see if they get sort of a second shot at a trial.
And the DA argued, don't buy the abuse excuse. I can't even imagine anyone arguing that today to a jury.
Yeah, different time. Okay, I want to move on to Idaho. David, I want to ask you the speculation about the Exhibit A in the grand jury, the part of the grand jury where they're now saying that they will get to have Exhibit A. But the problem is we don't know what Exhibit A is on the outside because it's all sealed and secret. It's apparently something the defense really wants, though. Give us an idea, David. What could this Exhibit A actually be?
Well, it could be something, Brian, about the prejudice to the grand jury. What are the documents that are going to supposedly inform this motion for basically a change of venue of where the case ought to have been indicted? I do think that at the end of the day, Brian, this is going to be a Hail Mary. I don't think this is really going anywhere because the prejudice was not just in this small town. The prejudice was all over the country. People were fascinated with this case. And so I don't think there's any real difference in terms of the demographics or of the exposure to supposed pre-grand jury publicity. And also at the end of the day, the grand jury just finds probable cause. The prosecutor shouldn't go into the grand jury without a belief and a conviction that there's proof beyond a reasonable doubt. But given that the standard for the grand jury is probable cause, and given the amount of evidence that backed that up, certainly beyond probable cause, that it was a murder filing and that it was murdered by Kohberger, I just don't see where this is going anywhere. I do think it's commendable that the judge is turning over the grand jury transcripts. As Sara knows, in federal court, we have a heck of a time trying to get grand jury transcripts or records about the grand jury. Even though we can make quite a showing that they might be exculpatory, we have to show particularized need in the federal court, and the judges are reluctant to turn them over no matter how much it would serve justice. So that's something that I think is commendable that they're being turned over, but I don't think, Brian, that this motion really is going to go anywhere. At the very most, they would get a new grand jury presentation in a broader area, in a different part of Idaho, and they would still return a grand jury indictment based on probable cause.
Yeah, I don't think anyone's arguing that this case has gotten an insane amount of media coverage, but Sara, other cases have too. Michael Jackson, OJ, the list goes on and on. Is that really reason enough to throw out, this grand jury indictment?
No, it's not. But first, to your point, that this is apples and oranges. This case is something else. It's on a whole other level. Bryan Kohberger has been convicted of this quadruple homicide. He is facing the death penalty, and by the way, he's a serial killer. That's really how we've been talking about him in the media. So it is different than some of the other cases that you named. But media scrutiny is not enough to throw out a probable cause and a grand jury indictment. what they can attack is how the media scrutiny impacted the investigation. So looking at this investigation, it seems like they narrowed in, they honed in this massive investigation on Bryan Kohberger, and then they tried to use these other pieces of their investigation to fit that puzzle, sort of working backwards. I think that's where the media impact matters.
But when we talk about the media impact, I mean, this is our world. We're like obsessed with this stuff, right? And most of our followers are into it. But like I had this interesting moment when I covered the Lori Vallow trial, and I was covering jury selection, and I was shocked like how many people didn't know anything about Lori Vallow. There are a lot of people that just don't watch the news, that don't really care, that don't, you know, aren't on Facebook looking at all the true crime stuff. I mean, I wonder if we sort of overblow that sometimes.
Yeah, I mean, I think that we, given the little that we know, you know, the irony here is that we have this true crime obsession that is leading courts to exclude cameras and issue gag orders, and then that then turns us into, you know, large speculators, and we're spinning and we're creating facts, and we think we know him, and we think, you know, everything that he's done in his life is looked at through the lens of guilt. You know, that's really the problem here.
Let me ask you, David, if he, I mean, I hear that you say it's unlikely, but if he were to win the challenge to the indictment, what would happen next? I mean, would they have to have a whole nother grand jury proceeding? Does that, I don't think I've ever heard of that happening. Does that actually happen sometimes?
Well, that could happen, but he would simply be indicted again by either a grand jury right there, or a grand jury in a different and broader venue, or, I don't know, a grand jury in Boise or something like that. I mean, this just is not a case where I think demographically there's going to be any difference. You know, sometimes there are cases where it's an all-white grand jury, and the argument is that somehow they've been selectively chosen from only one area within the district or division. I don't think that we have that here at all. So I think that this is going nowhere. Now, if something prejudicial was submitted to the grand jury, the judge could issue an order, don't submit that prejudicial item to the new grand jury. But trust me, Bryan, this one is going nowhere in terms of determining the fate of this case or the fate of Kohberger.
Well, one thing, though, to David's point, number one, I also practice in federal court, and yeah, but under Idaho, the Idaho code, the grand jury materials should have been turned over. So by code, they should have been turned over. But in a grand jury, you also have to present exculpatory evidence. And we've heard a lot of references to exculpatory evidence in this case that ranges from the DNA of 2 other unknown males to the statement of Bethany Franke, who was a witness, to this IgG, investigative genetic genealogy materials that the defense believes ties in with the profile DNA and is exculpatory. So, you know, there could be a problem that they didn't present this exculpatory evidence, because they're not, you know, there's a point of contention with this IgG, and the prosecution doesn't even believe it's admissible. They're not using it for probable cause. So it could be that because they're not using it for probable cause, and this is a probable cause hearing, that they didn't present it to the jury, and the defense thinks that's exculpatory.
It does seem in the recent filings, though, that we're starting to get a feeling for what his defense is going to be, at least at this moment. And it seems like a lot of it does have to do with the DNA.
100%.
Ann Taylor is really questioning how all that genealogy and all of that, and how they actually found him.
Right, she's questioning it. She's consulted with experts, according to her declaration. The experts have told her that this is not just a standalone, different kind of like art or whatever the state is calling it. The state's saying it's not even a science. She's tying it in with the profiled DNA, and so that goes to the reliability of the forensics in this case, and you know, and how they reached the conclusion of not just identifying Kohberger, but just sort of excluding anyone else that they should have investigated. You know, once they got the SNP and then they did the tree, you know, that the FBI did the tree,
yep.
They stopped. I mean, the buck stopped there, and it was Kohberger.
Well, I mean, but his DNA was on the knife sheath. I mean, they did connect.
But that is touch DNA. So DNA is a huge point of contention in this case. It should not be taken lightly at all. And I think the defense strategy that I can see so far is it ain't him. I mean, remember, proof beyond a reasonable doubt. It is entirely on the prosecution. And the defense, all they need to do is poke holes. And we're sitting here going, maybe he has an alibi. So what? Two things can be true. He may not have an alibi.
Yeah.
He may not be guilty. You know what I mean? So I think we look for that because it's more digestible and understandable. But at the end of the day, all the defense has to show is that they have not met their burden, and DNA is a big part of their burden.
Let me ask you, David, one of the issues that's come up with the DNA in this case is the defense wants the state to turn over all of the documents that the FBI has in relation to this ancestral DNA search that they did. They basically did this big family tree of Bryan Kohberger, and that's how they eventually figured out that it was him, they say. And so far, the state hasn't wanted to turn it over, saying, look, these are extended relatives, they have nothing to do with the case, and at the end of the day, we had the match from the knife sheath. Do you think that they should have to turn that over? I mean, do you think that's a big deal?
They should have to turn that over. They should have to turn over all the methodology. That can be done under protective order so that anybody in the family who thinks that their privacy might be, impugned or invaded won't happen, because there'll be an ironclad protective order that the lawyers will observe. But I just did want to say about the fact that he may have an alibi and there may be other suspects and so forth. I believe that as long as the DA believes in this case, my point was the grand jury indictment that you asked me about, that I believe that the grand jury, if the DA wants to bring the case and they believe in it, even if this indictment got thrown out, even if there should be exculpatory evidence that wasn't presented to that grand jury, that would be ordered to be presented to the new grand jury. My point was just that a grand jury would indict this case. Then, of course, when you get to the trial phase and the motions, of course, all the exculpatory evidence, all the Brady information should be turned over, must be turned over. And this DNA, every single bit of it, every bit of the work that they did, every bit of the experts' analysis has to be turned over to the defense attorney so that there's a fair trial and so that they can do their own examination, including get a little piece of the DNA so that they can have their independent or defense examiner investigate, look at it, do the same test that the prosecution or the FBI did.
Yeah, I
love a prosecutor who crosses over to the right side, okay?
Right, yeah.
I just do. But
well, I do think there's this misconception, though, that everyone thinks that, everything's going to be out there at this point. I mean, sometimes stuff doesn't come out till trial.
Absolutely.
I mean, we don't have to have everything in the documents yet.
Absolutely. And to David's point, I was digging up this whole, this it just wasn't settling with me that the state is not turning over this FBI stuff. As David said, they should. And the FBI, under certain circumstances, asks for NDAs from local law enforcement when they are involved in investigations. They don't want their methodology out there. So they ask. So I wonder.
I didn't know that.
Yeah, me neither. I just learned. And so I wonder whether there's an NDA in this case. And that's why the state's just has a death grip on it.
I wouldn't be surprised. They want everything to be secret. I mean, I wouldn't be surprised. Just real quick, we only have 30 seconds left. I'm curious, Sara, do you think it's strange that nothing about motive has come out yet on either side in any of these filings? We've heard all sorts of stuff, DNA, but we haven't heard yet why.
Right. And, we better hear why. I think every juror wants to know why, even though motive is not an element of murder or any crime. What is this connection? I mean, so far the connections we've heard of have been really just nothing burgers, that he followed two of the girls on social media. So what? I mean, I follow a lot of people I don't even know I'm following, so they need an explanation, and they really need to. I think the lack of evidence matters as much as the presence of evidence matters. And when we're talking about exculpatory, it's not just the presence, it's also the absence.
Yep.
There is not a single bit of biological matter anywhere that, in his car or anything. And people are saying he cleaned up, but there's no evidence of a cleanup.
But you are a defense attorney. That's your job to find those parts of this. I mean, if you read the probable cause.
I'm not looking for biological matter.
No, but there's a lot there, though. I mean, with the cell phone data, the cell phone being turned off.
I'm talking about forensic. I'm talking about biological matter from force lanes.
But maybe he just knew how to clean up really well.
But see, in the state's papers, the state says there is no explanation for this lack of evidence, and cleanup is an explanation. So that's why I'm saying, if there was a cleanup, we would have learned something about there was a cleanup. He had bleach, or he had whatever. And so that's the problem. It's 8 hours later they show up. This is a party house. We don't know who was there. And the house, all they get is a latent footprint. What is he, hopping, or he's one-legged? I mean, one latent footprint and the sheath. So there's a real void here of forensic
sheath
evidence.
is big, though.
The sheath is
is
touch
big.
DNA, which is problematic in the world of DNA.
It's going to be interesting. Sarah,
yeah, it will.
You're always helpful explaining it. David Katz, thank you so much. I also wanted to let you know, Sarah actually has a new podcast out called The Presumption. You can check it out on YouTube, wherever you get your podcasts. It's all over the place. Just came out a little while ago. I checked it out, so it's awesome.
Uh-oh.
All right, thanks, guys.
Sarah.